Welcome back to Good Law, Bad Law. In this episode, we're following up on episode 104 to talk a little bit more about marijuana law, and in this case, a really powerful human interest story. My guest is Joe Rogoway, a lawyer in California who took on a pro bono case on behalf of a 5-year-old girl with a medical condition that really was only treatable with a cannabis oil. Unfortunately, the school where she was going to attend kindergarten refused to let her into the school with the cannabis oil. Well, Joe took on the case, and I'll just tease it by telling you things that work out pretty well for this little girl and her family. And it turns out it was one of the most rewarding experiences of Joe's career, too. It's a great story about the impact of the law when it comes to marijuana and some of the controversies and disputes we're going to be seeing more and more of down the road as more states deal with this issue. So stay tuned for a great story. My guest, Joe Rogoway. I know you'll enjoy it. Thanks. Welcome back to Good Law, Bad Law. My guest on today's episode is Joe Rogoway, a California attorney. Joe, thanks very much for being on the program.
Good morning. Thank you for having me.
We are going to be talking today about a fascinating and I think really important case, one that was probably unimaginable even just a few years ago, but now one that we're going to, I think, be seeing more and more of this kind of case as marijuana and cannabis products become more openly available and more widely used. And this is the case of a kindergarten girl in California and a battle that Joe, on behalf of her and her mother, you fought so that she would have the right to use this cannabis oil, which she needs to treat her medical condition while she's in school. An incredible story. And so I really appreciate you being on the program to help us understand this and tell that story. First, give us a little background, Joe, on yourself. And obviously, you're a lawyer in California. Tell us a little bit about what you do in your practice.
Yeah, absolutely. So primarily our firm works with companies in the cannabis industry. So most of what we do is representing businesses. We represent businesses that are looking to first get created, to acquire properties, to get those properties entitled. We do a lot of financing, so a lot of the capitalization. We do a lot of that transactional work, disputes, intellectual property, things that are enriching and important, and we enjoy doing, but very different texturally from the pro bono matter that we worked on with the Adams family. So largely what we do is, represent businesses up and down California to assist them in participating in California's legal cannabis industry. And so this was, for us, a very exciting opportunity to make a real meaningful impact in the lives of both Brooke Adams, the child, the student, as well as her entire family.
And I want to get some detail into Brooke's story, but just to set the scene for us here in California, it was really just at the beginning of this year that marijuana for all uses was made legal, right? Give us that key background so we understand. Because first it was medical use, and then it was expanded more broadly just recently. Is that right?
That's correct. So California is the first state in the country to pass medical marijuana laws. That happened in 1996 through the Compassionate Use Act, known here as Proposition 215 as well. And that was a very sort of short, briefly worded initiative that essentially just authorized physicians to recommend cannabis to patients, for those patients, upon recommendation, to be deemed qualified patients, and for qualified patients to be able to use and cultivate medical cannabis. And with that, there was really no ability for any sort of supply chain for the whole procurement process, the entire ability for a medical patient to purchase cannabis was nothing that was really contemplated within Prop 215. And what happened in the late 90s was there was a whole bunch of sort of informal, what we would now call dispensaries, but they're at the time called compassion caregiver clubs. And they were not recognized under the law. There was a whole bunch of cases that went up, and the appellate courts, all of them essentially said that Prop 215 did not allow for any sort of distribution of cannabis, notwithstanding some of the language for caregiving in Prop 215. And so in order to rectify that, the California State Legislature in 2003 enacted the Medical Marijuana Program Act, which is known as SB 420, which is Senate Bill 420. And that greatly expanded the ability for patients to produce and obtain medicine, and also created the collective model. So that was essentially about 23 statutes, almost all of which inured to the benefit of the qualified patient. And the most important statute that is in SB 420 is Health and Safety Code Section 11362.775, which is the collective statute. And so that is that collective statute.
You've just impressed me. Well,
yeah.
Well, I have to ask you this before we go on. So, I mean, what you're describing is I guess understandably what has to happen for an entirely new industry, one that previously was illegal to be created. And you know, first you have to set up the right to access this for medical use, but then you have then no infrastructure, and that has to be created not only in a business sense but in the legal sense. But you mentioned this bill from Senate Bill 420, and I mean, I have to ask you, and you are the expert here. I know that 420 is got a cult significance in the community of people interested in marijuana, let's say. Did the Senate bill get named? Did they assign that bill because of the significance of April 20th, or did April 20th become significant because of that bill?
The former. So 420 is something that is a term that actually goes back to the 70s for this group of students in San Rafael, which is about a half an hour north of San Francisco, called the Waldos. Like these kids called themselves the Waldos, and 420 was their coded language in high school to go smoke weed. So that term's been around long before medical cannabis. The way that the Senate bill was named was certainly a nod to Senate Bill 420, and it's definitely entertaining. But what sort of a consequence of naming the Medical Marijuana Program Act Senate Bill 420 is that when issues came up in the courts or in law enforcement or with prosecutors or just in the community related to the meaning, the implementation of that new set of laws, in some ways it sort of delegitimized it, at least colloquially. It's people sort of conflated the recreational use of the term 420 with a very serious set of laws to deal with cannabis. But yeah, certainly it was a nod to that. And in talking about sort of like pushing ahead for the new set of laws to get access. One of the things that was really interesting is that in the era of Prop 215, there was no ability to acquire cannabis. And so it's what Dennis Perrone, who was one of the proponents for Proposition 215, called the magic ounce phenomenon, where you could use cannabis, you could legally obtain it at least and cultivate it, but if you couldn't cultivate it yourself, there was really no mechanism for you to get it. So what's supposed to happen is it's supposed to like fall from the heavens into your lap so that you can consume it? Of course not, right? And so it's because of that inability for safe access that gave rise to SB 420. And it was a real problem because it had at the time, there was in the Bay Area, a lot of terminally ill people, a lot of people who were, coming out of the AIDS epidemic, and they were still going to, black market, back alley type of dealers in order to get their cannabis. There were real legitimate needs for people to get safe access to cannabis. And one of the things that was really interesting is, it's such a political issue, and it still continues to be one. It was just difficult to sell to the public, politically, rhetorically, the ability to sell marijuana at the time. And so the way that the dispensary system was actually effectuated in California in the early days is through that statute that I cited earlier, Health and Safety Code Section 11362.775, which is what created collectives. And essentially what that statute says is that qualified patients and primary caregivers can associate collectively or cooperatively to cultivate medical cannabis and not be subject to criminal liability. And that's basically it. And from those words, which is basically this like communistic, agricultural, cooperative, collective endeavor, those words is what was used to justify California's dispensary system until 2018. So from 2004 until 2018, California's retail cannabis system was premised on language that basically allowed qualified patients and primary caregivers to collectively cultivate cannabis. And so there was this whole progeny of cases that worked its way or their way through the California court system, really trying to identify what the intent of SB 420 was, what each one of those words really meant. And through those opinions, the courts basically held that, dispensaries are allowed under that provision, which, was definitely, I think, a liberal interpretation of those words, but something that was really necessary to provide safe access to patients, because that's all there was. And there's a host of other things, and some of the laws that are contained within SB 420 really continue to be relevant in this decision from the court, which I can discuss a little bit later on.
I do. Well, I want to come to one other dimension of this too, which is, you talk about legalizing first for medical purposes, then you have to create this infrastructure where you can get access to these products, but you also have to have the science develop these products, right? Getting access to marijuana is one thing. Getting access to it in forms, and I think this is quite relevant to the story we're going to tell about Brooke, to get it into a form where it actually has a medical application, that also must have taken some time to develop.
Well, yeah, that's one of the unfortunate consequences with cannabis being in Schedule 1. It should really be entirely descheduled. That's probably the scientifically appropriate way to handle it. With it being in Schedule 1, what that means is that there is
you have to explain that for people. That's important to explain.
Yeah. Okay. So in 1971, the Nixon administration enacted the Controlled Substances Act, and the Controlled Substances Act was really the most sort of robust way that drug laws in the United States were really codified into an extremely draconian regime of essentially having different schedules that correlate to the potential for abuse, that correlate to medicinal value, and essentially correlating to the harm of the user. And so there is Schedules 1 through 5. Schedule 1 is the most restricted, absolutely prohibited. And then it goes down to Schedule 5, which is the least restricted, and then things are descheduled after that. So cannabis as a Schedule 1 controlled substance is considered tantamount to heroin, considered tantamount to LSD. It's considered to be more of a problem, a dangerous substance than cocaine and morphine, which makes absolutely no sense. It's a complete asinine way to categorize cannabis. but nevertheless, that's where it is. That's where it continues to be. So, as a matter of fact,
but at the same time, and this again, we're setting the scene here with all kinds of different strands to this issue that are going to bear on the story of Brooke in this case. But this is one of those strands, right, where you've got a state law in California. And by the way, in the meantime, lots of other states around the country are starting to move in the same direction, some more slowly, some more quickly. So this isn't just something that, that relates to California, but you have a state law on the one hand, and then you have this federal law, the Controlled Substances Act, which at least in theory would be in direct conflict with all of what's going on at the state level, because under that federal law, marijuana is illegal. So you have the non-enforcement of that federal law. That's a pretty key part of the story, right? So I think you have to explain what that means and how important that is.
Yeah, absolutely. So, and that's something that has also been the subject of significant litigation going all the way up to the United States Supreme Court in a case called Conant v. Walters. And basically, the way that this all shook out from the Supremes was basically that doctors have First Amendment rights to recommend whatever they want to their patients. That's different than a prescription. And so that's why it's so important that the verbiage in the 40 or so states that have some type of medical cannabis program is not that doctors prescribe it, because a prescription is something that's very specific and very regulated under the Controlled Substances Act. That is just a recommendation that is protected as free speech. And then there's sort of the preemption issue. And essentially what has been found through a variety of cases is essentially that federal law does not preempt states to enact their own laws related only to state law matters. So essentially, the state of California is not saying that federal law is invalidated. It's not touched upon federal law whatsoever. California state law is dealing only with California state law, and therefore there's no conflict. Furthermore, state law enforcement officials, state agencies, state and local governments cannot act as arms of the federal government. So the local county sheriff or a city police department or the California Department of Justice, for that matter, is in no way, shape, or form enforcing the United States Code. And so it's those things that are really central to this broader issue as well as this case, because essentially when we're talking about state law, when we're talking about enforcement, it's a very sort of dynamic issue still. One of the things that's important to keep in mind is that something like 99% of all prosecutions in the United States generally are done at a state and local level. The federal government generally only takes about 1% of all matters through the United States court system. And so what we're talking about is just, there's a real lack of ability for the federal government to prosecute all cases. The federal government, even currently under the current administration, recognizes in sort of, the most sort of punitive statements that we've heard from the Attorney General on this issue, that they just don't have the resources to go through and enforce federal marijuana laws against everyone that is involved in cannabis. So when we're talking about just from a pragmatic standpoint, forgetting about things like the Cole Memorandum and other similar relevant issues or proclamations or things that have been promulgated by the federal government, it's just not pragmatic for the federal government to be able to go after state legal cannabis operators. Now, there is something that's very relevant to this, as well as something that the court in the Adams matter picked up on, which is a federal Ninth Circuit Court of Appeal case called United States v. McIntosh. And the import of that case is essentially there is a spending preclusion enacted by Congress that was initially called the Rohrabacher-Farr Amendment, that is now called the Rohrabacher-Blumenauer Amendment, where basically the federal government is not allowed to use federal tax dollars to investigate and prosecute state legal medical cannabis operators. And that was challenged in the courts by United States attorneys. And essentially, the Ninth Circuit Court of Appeal in U.S. v. McIntosh, which for us in California is the highest court in the land until you get to the United States Supreme Court, if and when they grant cert, then essentially what the court in McIntosh found is Congress meant what they said. They do have the power of the purse, and they are able to restrict spending. And so that continues to be the state of the law. And essentially what that means is that the federal government currently is not able to go after state legal medical cannabis operators, at least in the Ninth Circuit. I think that there could be other arguments in other circuits, but for us and relevant to this case, that's the state of the law. And all of that is relevant.
So just to summarize, so you have the Cole Amendment you referred to, which was essentially a memo that came, sorry, I said the Cole Memo, memorandum, which came out during the Obama years, and basically was a statement that said, we have this law, but we're not going to enforce it. We're going to take a non-enforcement position. And then there's this other amendment and then there's this amendment you're talking about, which says, although marijuana is listed as a Scheduled I controlled substance, we're not going to allow federal dollars to be used to go in and challenge states who are enacting and implementing cannabis programs just in their states. We're not going to use those dollars for that purpose.
That's correct. And the only slight augmentation I make to that is that the Cole Memorandum, at the time that it was released by the Department of Justice, and still to this day, I mean, I have a firm belief that it's just a platitude. I mean, the Cole Memorandum came out just after Colorado and Washington legalized cannabis for adult use, and everyone was looking to the federal government to figure out, what are they going to do about this? You know, are they going to come in and do a massive crackdown? Are they going to acquiesce? And so they kind of did neither, and they released this essentially policy position that does not have the force of law, that cannot be cited in court, cannot be utilized as a defense against prosecution or forfeiture or anything like that, that basically says, hey, United States attorneys, you've got a lot of stuff to do. We know that you have more important things to do than cannabis. And if you're going to prosecute a cannabis case, you should really look to see whether or not it falls within one of these 9 categories. And if it doesn't, then maybe you want to spend your time looking at other things. But if not, no big deal. You can prosecute whatever you want to. And by the way, this doesn't change the law that says that all cannabis is illegal and you can prosecute whatever. So there was really no way when it came out. You know, I remember clients being just so elated and feeling like they had some breathing room. There was just a lot of hype in the press about it, but in reading it, it was essentially meaningless. So in my mind, the repeal of that document was also about as meaningless as the initial enactment was. And incidentally, that it was repealed by Jeff Sessions. And
right. When Trump was elected and Sessions became Attorney General, they made a statement that they were no longer going to.
Yeah, it was rescinded.
I mean, I don't even know that you could say it was repealed, because it never really was anything to start with, as you're explaining it.
Right.
And the weakness, a fundamental weakness in it, is shown by exactly what happened, which is you have a change in administration, and they say, never mind to that.
Yeah, exactly. I mean, and that was always the fear, is that it was assumed that there was going to be a date and time when there was no longer the Obama administration, that there'd be a successor administration, and then they can do whatever they want to, and that's how it all played out anyway. And all of that was relevant to this case because it was the school district was concerned about federal intervention and federal liability. All
right, so here we are. So yeah, go ahead. You wanted to say.
Well, it's just what we haven't talked about is the most recent enactment in California for the legal regime that currently controls, which is MCRSA, SB 94, which is the California state legal commercial system for medical and adult use cannabis businesses. Everything from nurseries to cultivators to distributors to manufacturers to testing labs to retailers to delivery services. All of that is now subject to state and local licensing that provides full immunity from criminal liability, provides the ability for any adult 21 years and older to possess and cultivate and purchase cannabis. And that's the regime that we're in right now. And so in this matter, we're sort of dealing with all three of those successive regimes in different ways. There are pieces of statutes and pieces of opinions that sort of ripple through, essentially starting from 1996 through 2018, that made its way into this 22-page opinion from the court.
Okay, so and we'll shed light on those as we get through the story as we need to, but now we now need to bring Brooke into the conversation and tell us what her situation was, because this then explains how this issue presents and what the conflict was, and then we'll get into how it was resolved. But tell us about Brooke and what this problem presented as.
Yeah, absolutely. So Brooke is a really amazing person, and her family are just incredible and inspiring to be around. Brooke is a 5-year-old girl that has Dravet Syndrome, and Dravet Syndrome is a chromosomal disorder that creates this sort of rare form of epilepsy that is different than the sort of standard, more normal epilepsy that some of us may be acquainted with. Dravet syndrome, because it is chromosomal, does not respond the same to different drugs that work well for a more standard form of epilepsy. The seizures that happen as a result of this condition are more severe, are much more frequent, and last much longer than a standard seizure that someone may have from a standard form of epilepsy. And it is something that will never go away. Brooke will have it for her entire life. And it is just profoundly difficult experience for the entire family to go through with just trying to address Brooke's basic needs, because with the amount of seizures that Brooke has had, it has really impacted her development. And as a 5-year-old, she has delays in speech. She has delays in her motor skills. She has delays in how her social interaction goes. And it's because having so much of her time and her space that is taken up by the seizures themselves that really prevent her from developing. And so that's really central to this, because where this all started was when Brooke was 2 years old. She started getting seizures, and actually she started earlier than that, but they started becoming more robust when she was about 2, and it was a terrifying thing for her family, and they tried treating it through all sorts of conventional means and medications. The family, incidentally, is Mormon. They are not generally inclined to participate in anything related to cannabis. That was not at all an intuitive way to treat this for Brooke when she was a very, very young child. They tried Keppra. They tried a whole variety of different medications that were either ineffective or made things worse. And so there was several times a week experience that they had where first responders would go to their home and take Brooke to the hospital. There were times that they had to take these fairly hair-raising helicopter flights down to Oakland Children's Hospital to get her there. And she would be getting in and out of helicopters, being intubated, where they're trying to control seizures and not being particularly successful with it. And so, she had to go through a lot. And out of just sheer desperation, Brooke's mom, Jana, started going online and participating in groups of parents who have children also that have Dravet syndrome. just trying to figure out what they're doing and what's working for them. And through those communications, she was introduced by other parents to at least the concept of treating Brooke with cannabis oil. And after a while of just sort of like getting these informational inputs and having a real lack of success, and not just a lack of success with conventional medications, but it was actually making Brooke's condition worse. And some of the medications that she was given had side effects that could potentially arrest her heart. And it's just a really impossible decision, I think, for any parent to make, to give their 3, 4, 5-year-old child medicine that could end up killing them in order to save them from a condition that could also kill them. I mean, and that's the position that they were literally in. And so in that context, Jana was seeking every alternative, every option that she could to basically save her daughter, and then came upon cannabis and to your point, found this very particular product called Jaden's Juice that is available at one place in the center of California, in a place called Modesto, that she had to go, take a several-hour trip down there to procure it, and brought it back and started administering that to Brooke, and it was just immediately something that had an incredibly significant and material impact for her. And
now,
so
Joe,
they gave...
I understand that this product is, so for anybody imagining a 5-year-old smoking marijuana, I mean, that's not what this is, right? This is an oil extract that is given when she starts to experience a seizure, right? And then it effectively controls the seizure once that happens.
Yeah, well, you're correct that it is not smoked, and it's an oil, like a tincture essentially, that is just dropped under her tongue, and that's it. It's a very innocuous thing to see being administered. It is not at all like you're watching a 5-year-old smoking a joint. It is a nurse that is doing a sublingual drop of an oil, a very small amount of oil, and it's just a very discreet thing. It's administered both sort of preventatively. So Brooke gets a CBD-rich oil that is preventative, and that's something that she gets daily. CBD is something that that no one would really see as being impairing. It's something that is just sort of calming, and something that sort of reduces, anxiety in some people, inflammation in some people. But for Brooke, it's something that is used to sort of prevent the next seizure. When she's having a seizure, then she gets what's called a rescue medication. That is a THC product that is administered the same way. It's an oil that is just dropped into her mouth. But that's a THC-rich product. So she basically takes two different types of cannabis oil products, neither of which are smoked, and both have different uses.
Well, and the reason that I think it's important to understand and clarify is because lots of kids have lots of things that they need for one medical reason or another that they take into school with them. Kids have asthma, and they have to carry an inhaler. Some kids have severe allergies. My stepson has severe allergies, and there is an EpiPen nearby, and that would be a pretty scary thing to whip out if he ever needed it, but it's there because he might have a need for it. And so it's, I think, important to have a visual of what this is for this little girl, because as I understand it, what happens then is a dispute about whether she's going to be able to bring this product into school or not. That's really the dispute that takes place, right?
Yeah, and I think to your point, if we were talking about Vicodin, if we were talking about a whole lot of other substances that no parent would want their children exposed to if it wasn't medically prescribed, the school would have no compunction whatsoever about allowing those much more serious drugs, opiates, benzodiazepines, et cetera, to go to school with the child. And they would gladly administer those drugs, and I would say objectively, scientifically, much more powerful drugs that have a much higher incidence of abuse, of overdose, et cetera, the school would have no problems whatsoever with bringing that on campus and administering it. And so that's part of the supreme irony here, is that we're talking about essentially a very benign plant-based medicine that has no demonstrated potential for abuse, no recorded events of overdose that is being administered in a very discreet way that literally is, saving someone's life. And that's the problem. The problem isn't, like very powerful opiates that can easily be swallowed by a child that sends the child off into a hospital in a very dire situation.
So it seems, therefore, given everything we've talked about so far, just almost staggering that in, of all places, California, there is a little girl who needs this product and a dispute comes about because the school says no. In 2018, maybe in 1996 when cannabis at least was first allowed for medical use, you could see there being school districts who, have a higher anxiety level about all this. But in this, in 2018, it seems a little surprising. So what were the arguments that you had to overcome to get past this objection by the school district?
Yeah, so the school district had arguments both under federal law and under state law. So their primary arguments, and the arguments evolved over time. And essentially what they were arguing was that under federal law, you can just sort of, because it's a Schedule I controlled substance, one could essentially imagine a way that they would lose access to federal funding. They didn't articulate what federal funding was really their concern, what the actual risk was, or articulate any sort of notices or anything like that gave rise to this concern, but they had a sort of generalized concern that they were exposing themselves, the district, to a loss of federal funding and exposing the people that work there to some type of federal liability. That was one sort of chunk of their argument. Another component of the argument was that under state law, they argued that there wasn't the ability to administer cannabis on campus. And they were citing a couple different things. They were citing the laws that go back to the Compassionate Use Act related to transportation, and I'll get to that in a moment. They were citing laws related to the Medical Marijuana Program Act that related to where one can smoke cannabis, and that goes to your point of this being non-smoked cannabis. I'll get into that in a moment. And then they were citing laws that under McCursa saying that people can't have cannabis on school grounds. But the issue there is that particular statute talks about the adult use, 21 and older. It doesn't talk about minor students that have a doctor's recommendation. But in any event, their primary arguments were federal law prohibits this. We can't do something that's against federal law because bad things are going to happen to us. And a variety of different state laws prohibit it as well. And because it's prohibited under both federal and state law, then I'm sorry, our hands are tied. We feel for Brooke and her family. It's terrible, but she can't come to school with cannabis.
And so as I understand it, the school proposed, and she had a IEP, an individualized education plan.
Correct.
Brooke did, and as I understand it, the dispute takes shape because the school says, sorry, she can't do this in school, but we'll offer that she can be at home. She can basically be homeschooled, and we'll provide 1 hour. We, the school district, will provide 1 hour of instruction to her in her home. And now we have an issue under federal law about whether this is appropriate, free and appropriate public education, FAPE. And that's really the form of this dispute. Is an administrative proceeding to determine if the school is justified in that rather than in allowing Brooke to come to the school. I mean, I know that's a very big oversimplification, but is that essentially the shape of this?
It is, and the only thing I'd really add to that is that there was a prior IEP when she was looking to be placed in preschool. In California, when there are children with real significant deficits or medical issues, they go through what are called regional centers, and the regional centers essentially have jurisdiction over the care for the children until they get to age 3. Then once they hit age 3, then they come under the purview of the school district, and that's when the school district starts to take over through IEPs. And so essentially Brooke had an IEP when she transitioned from the care and oversight of the local regional center into her local school district. And that's when she first started dealing with this issue, and when her family first came to us. So when we first became involved, it was really just about trying to help work through an IEP process that can allow Brooke to go to school and have access to her cannabis oil in a preschool setting. And essentially, the accommodation that was worked out for that earlier IEP was that Jana, Brooke's mother, had to go and find a preschool that would accept her. The school district said, had the same argument. We can't do this for the variety of reasons that I had mentioned earlier. And if you find a preschool, though, then she can go to the preschool, and essentially through the IEP, we'll be funding her attendance at whatever preschool you find. And Jana looked and looked and looked and looked and was able to find one preschool that would take her, and that's what happened. And so through an earlier IEP, basically the school acquiesced to placing Brooke, the school district acquiesced to placing Brooke in this preschool where she was able to have her cannabis oil administered. The issue really became something that became much more contentious when it's an annual IEP, so the next IEP came around, and Brooke was aging out of the preschool environment and going into kindergarten. And basically the school district said, well, now that you're going to kindergarten, there's basically nowhere for her to go. And that's when they came upon the solution that you were referencing, which is basically that we understand that she needs to have cannabis. We don't want to prevent her from having cannabis and have some terrible medical event transpire, but we can't have her at school either. So what we'd like to do is to just give her up to an hour a day of education at home, and then that is sufficient, and that meets our obligations under the IDEA, which is a federal law that relates to just giving access to disabled children for education. That this is the FAPE that you referenced. That's the free and appropriate public education in a least restrictive environment. So basically saying that the school is saying they meet their federal obligations to provide public education to this child by allowing her to be homeschooled for up to an hour a day. And so that was something that the family and ultimately the court, but first the family felt was entirely inadequate. It's just not the same at all. And for any of the listeners that have children out there, just imagine rather than sending your child to school, to kindergarten or whatever grade it is, where they have access to the classroom environment, where they have access to friends, where they have access to social and emotional learning, where they have access to all these other things, and say instead of getting that environment, which is enriching in a number of different ways, instead they can stay home and have up to an hour a day. Totally inadequate. And so that's when this turned into a larger dispute, when basically we did what's called a due process hearing, appealing the IEP and trying to get the Office of Administrative Hearings, it's an administrative law judge from the California State Special Education Department, to come through and render an opinion as to whether or not there is a real FAPE that is being offered by the school district in this instance.
Well, and there's a decision from the administrative law judge, Judge Marson, a 22-page decision that just came out a couple of weeks ago, explaining the background of the case and how the judge handled all of these issues and ultimately ruled in favor of Brooke and her family and you. We'll post a link to this, by the way. It's a great read and gives a lot of background, a lot more detail that we can cover here today. But Joe, I mean, what an incredible result. And I'd like to do two things as we get toward the end of our time. One, if you could explain how you summarized for us what the school district's concerns were. How did you overcome that? What did the court find compelling? And then I want to just spend a minute or two to broaden this out. And, you know, Canada has just announced that it's legalizing marijuana in Canada. I mean, there's a movement here that is more widely accepting of not just marijuana, but cannabis and cannabis products, cannabis drugs. And, you know, it's clear where we're moving, and this may become more and more a relic of the past. But on the other hand, there may be also more points of controversy as more states and more communities try to deal with this. So I think it's useful to understand. First, how did you overcome the school district's objections? What did this judge find compelling here?
Yeah, so first, with regards to our arguments, at a state level, our arguments were basically that the authorities upon which the school district was relying on were misplaced. The arguments, for example, of no marijuana products whatsoever on school grounds for medical patients being against contrary to state law is something that is just not true. So the particular statutes that were cited by the school district, for example, one of which was Health and Safety Code Section 11362.83, that code section really only applies to smoking. That's the explicit express verbiage in the statute itself, that no one can smoke marijuana on school grounds. But of course here, no one is trying to smoke marijuana on school grounds, but right, as discussed earlier, is getting an oil administered sublingually. So that is just inapplicable. Right. The other statute that was referenced was a provision from the new enactment, SB 94, that basically says that adults 21 years and older who are otherwise able to use possess marijuana can't do so on the school. But that does not apply to Brooke either, because she's not an adult. She's not subject to all the other statutes that were referenced in the provision that the school district was relying upon, and it was just inapplicable to Brooke. So those were actually like fairly easy to defeat, because the express language of both those provisions would just undermine the school's position. And, you know, I think maybe, you know, the school this probably just isn't an issue that they're used to working with or litigating, and they just kind of saw these provisions out there and kind of relied on them without maybe looking too far into it. But those arguments were actually like fairly straightforward in terms of how we were able to counter and overcome them. There's also, just as an aside, one of the arguments that the school district threw into their briefing towards the end was basically that the transportation in the school bus of the nurse bringing the cannabis oil with Brooke to the school district, or to the school itself rather, was in and of itself illegal, because transportation is not allowed by patients and caregivers. And that was just an asinine argument. I mean, this goes back to a case in 1997 called People v. Trippett, where the California Court of Appeals, just before SB 420, in the very early days of medical, held the obvious ability for patients and caregivers to transport. And then this was subsequently codified in Health and Safety Code Section 11362.765, that qualified patients and primary caregivers are allowed to transport. So the school making that argument was just really unfortunate, because it's just so clearly not the state of the law. And it was really unnecessary, because it has nothing to do with their primary stated concern of them having their own liability for cannabis on school grounds. They were trying to undermine the ability of the nurse to even transport it to school. So all those were overcome. We cited points of authority to the court. I'll get to just how amazing this opinion is and how well researched it is in a moment. But the next issue, just to answer your question as it relates to federal law, is that there are different federal laws that deal with different things, right? So there is the Controlled Substances Act, as we discussed, and there's the IDEA, as we discussed.
Federal education law, yeah.
Yeah, exactly. And it's the Individuals with Disability Education Act. And basically, the school district was trying to pick one over the other. They have obligations to provide education, public education, to all children. It's a right. It's a federally guaranteed right. And the school district doesn't have the ability to contravene that right. And essentially what they were doing is they were contravening that right by essentially saying that the Controlled Substances Act is the only thing that they're going to pay attention to, or what is going to be controlling. But the Controlled Substances Act, if you look at it, there isn't really anything that the CSA says that criminalizes whatever the school would be doing. I mean, I guess conceivably there would be some sort of abstract academic theory of liability of some larger conspiracy for the nurse to possess it. But I mean, it's just such a remote theory that it just didn't turn out to be persuasive to the court, because the court rightly found that when we talk about the things that we were talking about earlier, United States v. McIntosh, the federal government can't go after state legal medical cannabis patients anyway. So as long as U.S. v. McIntosh is the state of the law, then there's really no liability there. The school district was not able to articulate any type of funding stream that was going to be jeopardized whatsoever. It was just abstract and just unsupported. And they had some sort of tangential reference to the sort of drug-free school zone issue, but that doesn't really interface with this issue at all. And so the court, I think, rightly found that essentially in the totality, the arguments that were promulgated by the school district were entirely specious, and they were just not persuasive. And just to give you an idea of sort of the level of agreement that the court had with our position and disagreement with the school district's position, if your readers or if your listeners read this 22-page opinion, it's an emphatic endorsement of our position, of Brooke's position in this, and an emphatic repudiation of the school district's position. I mean, the court went way beyond what we were arguing, and we had some fairly robust briefing and arguments that went into this, and really just did such a well-researched, well-documented, cogent opinion that completely eviscerated the school district's position, just shredded it. And for someone who has spent a lot of time litigating matters, I've done a lot of jury trials, I've gotten a lot of written decisions back in both the trial and appellate courts. I can't think of anyone other than this that I have had such a strong endorsement of the position of my client that adds to this opinion. I mean, it was, in reading it, it was something that first, myself and everyone in the firm who worked on this matter was teary-eyed because we won, and we all put a lot into it. It was a big deal. It was something that was really meaningful for us attorneys to work on, but also just intellectually. When we read the decision, it's just something that is just such a profound endorsement for the position that in California, children with disabilities have a right to go to school, and that includes their ability to use cannabis oil in the school setting, is something that it's incontrovertible based on how the court wrote this opinion. And although this case doesn't have precedential value in a formal sense, it is certainly a watershed moment in the community of the legal community that deals with these issues, and is something that other districts are already utilizing to justify allowing children to attend school with cannabis oil. So the impact has been absolutely profound, both on a larger sort of legal sense, but also in a very personal sense for Brooke, her family, and the people in my firm that worked on this case.
Well, and you're right that, I mean, as a technical matter, there's no precedential value, meaning a judge in Kentucky or New York or Alabama doesn't look at this ruling and say, oh, I've got to follow this, because all this is going to be a matter of state law. But I have to believe, as you suggest, that this is going to be very influential, because first of all, it's California, which has led the way all along, and look how many states are now following California's lead. But also, I mean, cannabis at this point, I mean, we've come a long way since Reefer Madness, and I actually remember being in high school and showing us that movie, which was really pretty funny. We've come a long way. One of your expert in this case was, or one of your experts was Dr. Joseph Sullivan, a pediatric neurologist, an assistant professor. I'm reading from the opinion here, an assistant professor of clinical neurology at the University of California, San Francisco. By the way, one of the leading medical institutions, I think, in the world. And, one of the leading experts on epilepsy and treatment. So this is mainstream medicine. It's now mainstream law. It's mainstream in terms of how many states in the country are, starting to embrace and now grapple with this. So I would think that this opinion not only has changed the life of this little girl, and that has to feel pretty good for all of you who worked on this. But I have to believe it's gonna reverberate and have a very powerful influence as other school districts wrestle with these kinds of issues going forward. Don't you think?
Yeah. I mean, some of the feedback I've been hearing ranges from other parents bringing this decision into their IEPs to show their school district, what happened here to persuade them to do the right thing with their child. I've also heard from educators, from administrators for large school districts in California that are using this decision to justify a change in policy for special education programs district-wide for large school districts. And so you're absolutely right that there's a ripple effect, and although it doesn't have that technical precedential value that us attorneys rely upon to cite authority, it absolutely has the impact of precedential value in communities that are grappling with this issue. It's just an incredible thing to be part of as an attorney. It's just incredibly professionally and personally rewarding. And I sincerely hope that school districts across the country see this decision and then utilize the decision to justify allowing children in their districts to access this life-saving medical treatment.
Well, Joe, it's an inspiring story too. And I mean, you took this on, as you told us, pro bono, meaning you took it on for free. But I also have to believe it was a labor of love, and I know you got a lot out of it, and so that's great. Congratulations on the case. I will, as I said, post the opinion or a link to the opinion, because I do think there may be people who want to print it out and have a copy for themselves, other parents of special needs kids all across the country. So, and for everybody else, it is a very good read and a fascinating story. And a great privilege, Joe, to have you share the story with us today. And I thank you so much for being on Good Law, Bad Law. Thank you.
Yeah, absolutely. Thank you for having me.